All right, everybody, as we're getting to the top of the hour here, we're going to get the CLE underway. Appreciate you all being here today. If, as we're going through the program, some of you might be taking this for CLE credit. Please make sure that we can see your full name on your Zoom window. That's one of the ways we track attendance. At the end of the course, we do have a requirement from a lot of the state CLE providers that we have a sign-in sheet, and we'll give a password for those states that require it. We're offering the CLE credit to multiple different states, so the requirement's a little different for each state. And so anyhow, you may just see some things for other states that you don't need, and that's fine, but we just put it all in there anyhow. So today's presentation is going to be about who owns a trademark, talking about structuring trademark ownership and buying and selling trademarks. It's ironically a question that sometimes seems so innocuous and sort of almost like we get brought into transactions almost at the last second when someone thinks they need to ask a question about this. So we thought it'd be an interesting topic for today. For those of you that are joining us for the first time, a little bit of information about our law firm. Gerben, Perrott, I'm obviously Josh Gerben, Eric Perrott, my law partner is here today as well. We're celebrating our 15th year this year. Opened the firm in 2008, which is hard to believe. Means we do this another 15 years. I'm going to be pretty old, but here we are. The firm has we have 8 attorneys, kind of scattered around now. I'm up in Pennsylvania outside Philadelphia, a bunch of lawyers in Washington, D.C., one in Vermont, one in Florida, and now one in Nashville as well. So kind of scattered out on the East Coast here. Our firm is primarily a trademark firm. So over the last 15 years, we've obtained 7,300 plus at this point trademark registrations for clients in the United States. We also have filed and registered trademarks in over 30 countries around the world for our clients. We do a significant amount of enforcement defense work. Most of that settles outside of court. So we take that as a badge of honor that we don't need to use the court system, but in rare circumstances, we've probably settled, we have settled over 300 trademark disputes. We've also overcome over 200 substantive U.S. Patent and Trademark Office's refusals. So that means if a client's trademark application's gotten refused because of another trademark or an issue concerning the validity, if you will, or strength of its own mark, we've overcome those refusals. And also we've settled or resolved over 200 trademark trial and appeal board cases, which is the court within the trademark office. So our practice on the trademark side is very wide ranging, but we really don't do much else. Hence the conversation today about trademark ownership. So thank you again for joining. And we've had a number of people join in the past couple minutes. So I'll just put the PSA out there again that if you're joining for CLE credit, at the end of the presentation, we'll have a sign-in sheet for you. We'll give out the password for those states that need it. And, if you have any questions along the way, feel free to put them in the chat, or you'll have our contact information at the end if you need anything. I am more than open to answering questions during these. Matter of fact, I love questions, even though I rarely get them. Feel free to put them in the chat. We'll be monitoring it and happy to answer any questions as we go. So please don't be shy and help us out by throwing a question out there now and then.
Hey, Josh, before you get started, I just want to let you know that there is a Q&A section and we have some people asking questions there. It looks like the chat's disabled. I'm working to fix the chat, but right now the questions are just more around the names. Anyone who's unsure if their name is correct, if you just send a question and answer with it, I can rename you and make sure that you're named properly in the system. Thank you.
Thanks, Lacey. Yep, I got that open now too, so feel free to use the Q&A section as well. This is actually our first, believe it or not, this is our first presentation with Zoom. We had been using Google Meet. We outgrew that given the number of participants. We're up to, right now, we're up to 119 people in the presentation. We're expecting up to 200. So Google Meet, whatever reason, we're now on Zoom. So forgive us, we're learning as we go here a little bit. The topics for today, we're going to start with basic questions. Seems basic enough. Who should own a trademark? Then we're going to talk about what happens if you need to buy, sell, or transfer a trademark right. And we're going to kind of put a cap on it and talk about a really interesting real-world story with Dallas Mavericks star Luka Doncic and the trademark battle he had with his mom, of all things. That'll be the structure here for today. And so let me jump right into it. Sorry, I have to get on the screen. There we go. If you've been to a CLE before, you've heard me say this, but I want to lay the foundation for what is actually a trademark so that when we talk about the rest of this, it'll make a little bit more sense. By its nature, a trademark is what we call a source identifier, meaning it is essentially a shortcut for consumers to identify what company they're buying a product or service from. So when you see Nike, you know that Nike Inc. is selling you that shoe. You know where the shoe's coming from. And trademarks can be a lot of different things that consumers use to recognize products. Obviously, a business name in Nike could be the name of ancillary products or services. So sometimes, a company may have a corporate name, but then different names of different products and services. Can have slogans or trademarks, logos. You even have things like trade dress, how a product looks or feels. Sounds can be a registered trademark. For example, did you know that the Netflix ta-dum, when you turn on Netflix, that sound is a registered trademark. You can even get trademark registrations on colors, patterns, and shapes that consumers might identify the particular product. With shapes, you could think of like liquor bottles that might be really obvious, like a Maker's Mark bottle with that unique wax cap that they have, a protectable trademark. So
Josh, the scent of Play-Doh recently became a registered trademark.
There you go, scent of Play-Doh. So that really, I'm sure we could all smell that and immediately be thrown back into our childhoods. Good nostalgia. Probably need to get a jar of Play-Doh and just leave it on my desk. But yeah, so that's a registered trademark now as well. So trademarks are pretty cool. A lot of different things, and you interact with them every day, whether or not you realize it or not. Just to kind of give you the actual real world examples here, you could see, a business name, Starbucks, we all know, they have different products. Puppuccino was a product or is a product. And so they have that. They have a slogan called Building a Future with Farmers. They've registered logos, and then the trade dress. If you see that cup with that green circle on it, you probably think of Starbucks or know that's a Starbucks cup and from a Starbucks coffee shop. So these are all different things that people can protect with trademarks. So getting into the first question here, who should own a trademark? Seems innocuous, right? If you open up a trademark application on the USPTO electronic filing system, which is now how you have to file trademark applications, and this will be the first question. It'll ask you, who do you want to own the trademark? And this could be a number of different. This could be something like, it could actually be a person, like I, Josh Gerben, could own a trademark. It can also be a corporation, an LLC. If your client happens to be based overseas, it could even be a foreign entity. It doesn't have to be a U.S. national or a U.S. entity. It could actually be foreign national, a foreign entity. Could be a partnership. It can even be a trust. Trusts and estates can also own trademarks. So there's a lot of different ways you could structure ownership. If the owner is going to be a corporation or an LLC, keep in mind this could be an operating entity that your client has, or it could be a parent or a holding company that owns intellectual property and licenses it out around the organization chart. The key element here is that if you put the wrong thing in as to who's going to own the trademark, USPTO doesn't know. They're not going to say, hey, you said that this is the owner of trademark, but are you sure? Or should it be this person or should it be this company? They're not going to investigate it at all. They're going to take your word for it that this is the company that owns the trademark or this is the individual that owns the trademark. If you are wrong, a registration will still issue, provided that all the other sort of technical details are properly met. But the trademark could be what we call void ab initio. It's Latin for basically void from the start. There's the registration, if ever challenged, would be canceled because you couldn't substantiate that was the proper owner of the trademark.
And Josh, we had an exact issue where this happened, where this was maybe 3 or 4 years ago when we found out in a TTAB, which is the appeals board, found out that the person we were up against was actually a law firm who did it on behalf of their client. And that was actually the crux of the case, is that they claimed they were the owners when it was actually their client who was the owner. And that turned the entire case around and we ended up settling it. But it really was on the basis that that trademark registration that we were disputing was void. And it was from the minute they filed it in their name instead of their client's name. And I thought that is something that seems so innocuous to just, oh, well, we'll switch it later. And absolutely, you can't do that and fix it later.
Yeah, that's a great point. And I mean, another example, we actually see this quite frequently, is that if a president of a corporation files a trademark in his or her name personally, but the corporation was supposed to be listed as the owner, also completely voids the trademark application. And that's something you'll see with a lot of small business owners, is they might say, oh, I'm going to own the trademark personally. I don't want to put it in the company, or well, they can do that. Or they might just think that, oh, I'm going to put my name here, but the company should be the owner. Again, that voids the trademark application from the start. So what we have found in our practice over the years is that you might ask someone a question like, who should own this trademark? Like, do you have and then they give you an answer. And it's really important to follow up with, well, why? And sort of get and pull on the strings a little bit to see if there's anything else there that you need to know. Because you'd be surprised how many folks have very strange corporate structures, or might have different reasons for what they're trying to do with an ownership of a trademark. And it's really our job as attorneys to figure out and make sure we understand everything that's going on with the client's business and why a particular entity or individual should be listed as the trademark owner. And I'm just trying to get to my next slide here. Sorry. So that comes back to the question of who's going to be the correct owner. Typically, again, it should be a corporate entity. An individual can be listed as a trademark owner, but I would always counsel a client that wants to own something personally. Are you prepared for the personal liability that could come with a trademark infringement lawsuit? If we're not separating out your assets here into some kind of company. Some individuals may say, well, I don't want to trademark in that company. I have other partners, or I'm worried about losing the trademark through a bankruptcy or something like this. Well, they could consider having the trademark in a holding company, another entity that would then license the trademark out to the operating entity. So there's different things you could do there. But I'm always a little skeptical of someone that wants to own a trademark in their own name. Normally, that just indicates that the person is very, very early on in any kind of business venture, hasn't really gotten good legal advice about setting up corporate entities and how that should be done. So just something to kind of flag if you see it in practice. The other thing that comes up very frequently is, ensuring that the corporate entity your client's given you is the proper entity that owns a trademark. We sometimes have clients that have 9 or 10 corporate entities in their corporate structure, maybe more. And they'll say to us, well, this company should own the trademark. And my first question is typically, can you give me an organization chart? Let me get a flow chart of how all your different entities are connected or not. Because if they might have this idea that they want one company to own the trademarks, but that company is like a subsidiary of a bunch of others. And that would be incorrect, because the company that has to own the trademark is the company that can control the trademark. That can control the quality of the goods and give instructions to the person or entity using the trademark on how the trademark should be used. So it's very important that corporate entity sits atop the corporate structure and is not somewhere on the bottom rail, which you would think that's kind of obvious, but you would be surprised how often folks kind of throw trademarks in entities that they shouldn't. So truly understanding your client's corporate structure, if they have more than one entity, very important thing to do. So again, as far as the practice tips here, like if you're handling something like this, always ask the client for their organization chart. Make sure we can visualize all the different entities that are involved. We also then need to, if the client does have multiple entities, really need to think about putting licensing agreements in place. So if you've got multiple entities, a parent company can own the trademark. Well, now you need a license agreement to any subsidiary that's using the trademark. And it should be in writing. I mean, arguably you could do oral licenses, but it's not a great way to go about things in case there's ever a dispute or a problem comes up. So that's something that you just want to really think about if you have multiple entities involved. And then the other thing, and this is like the most important thing, and it's the most obvious, you have to make sure the company is actually formed before you file the trademark application in the name of the company. Incredibly surprising how many people will tell you, I want to file this in XYZ Inc. And you go, okay, send me the corporation, the incorporation documents. Or you go on the Secretary of State website to verify the corporation status, it just doesn't exist. They're like, oh, no, I'm going to file that. That's the company I'm going to create to own this. No. if you file the application, the name of a company doesn't exist, again, we're void. Like we have to refile once the company is formed. So that's something to be very careful about. The other thing that we always check before we file an application is if the corporate entity is actually active. You would also be surprised about how many people just don't pay like the maintenance fees and their corporation goes inactive or is dissolved by the state for failure to like keep up with all the necessary maintenance filings. So again, you could be filing the trademark in the name of a company that doesn't exist, and that would be a huge, huge issue. And most of these issues don't come up until there's a problem because nobody figures it out until there's litigation and opposing counsel starts poking around and sees these kind of issues in the prosecution of the trademark application.
Yeah, and we had a question, Josh, about if you do file defectively, what happens to your priority date in that application? And the answer is a little bit more complicated because trademarks can exist outside of owning a trademark registration. There are unregistered common law trademarks. But when it comes to the pure question of, do you keep your priority date if you have the wrong owner? The answer is no. And so if you filed that and someone else filed the next day and yours is void, then if the earliest priority date that person has is that application date and the earliest you had was your prior application date, then there is a situation in which they would have priority. And so it is extremely important. And that is in some cases an incorrectable thing that you have to refile and get a new priority date. Yeah, there's a lot of kind of nuance to that. So we would kind of take it on a case-by-case basis of what to do in that situation. But you do lose that priority date if the application was filed in the wrong name.
That could be, I mean, potentially devastating, especially if the client hasn't made use of the trademark yet and you filed an intent to use application and got a priority date and then lost it. So obviously just something that we're very careful about when selecting this owner. It seems like a very innocuous question, tons of potential landmines, to deal with there. I think we got another question.
Two more questions. Yeah, that actually go, I think, really well into the next section we're going to talk about trademark assignments. Is that if you did file in the name of an owner when it's really the company who owns it, then can you do an assignment instead of refiling it? And in most cases, in the example of if the president of a corporation files in his name personally, but the corporation was supposed to own it, then that is an incorrectable error. That's one of the things that says you can't correct that with an assignment, because an assignment says rights were transferred. And if that's not true, and we'll talk about that, then that can't be corrected. In some cases, you can, if the owner of it was an individual and they had control over it, and then they're transferring those rights to a new LLC or to an existing LLC, and now that LLC owns it, an assignment is a perfectly acceptable way to move trademark rights from one person or one entity to another. But if it was not filed in the correct name to begin with, then most of the time it's going to be something that's going to be very difficult to correct with an assignment, because in that case, no rights were being transferred. And we'll get more into that, but that is something just to be very careful of.
Yeah. And there's also things like there are correctable errors in the sense that, like, let's say you filed the trademark and said it was a Pennsylvania corporation, but it was really a Delaware corporation. Well, as long as there wasn't another company in Pennsylvania named that, whatever that name was, you could actually correct that error by just filing an amendment and say, no, we meant it's not a Pennsylvania corporation, it's actually Delaware corporation. So it's funny because there's some things you can fix if it's a mistake kind of, but if it's really just identifying the wrong owner, then that's where you really get into trouble. So next slide. I want to give you a real world example. Sorry if there's any Tom Brady fans in here today. I have no sympathy for Tom Brady being an Eagles fan, but so Tom Brady filed trademark applications for TB12. You all might be familiar with this brand. Incredibly, the trademark applications list his agents as the owner. So here is the actual application itself. This is what it looks like in the USPTO database. And you can see here that Yee and Dubin Sports LLC, those are the agents that Tom, I don't know if he's still using them, but definitely using them at the time. So they filed in the name of their sports agency. Why they would do that is really a head scratcher. But nevertheless, they did. And again, the question here is is Yi and Dubin Sports really the right owner of TB12? Like, were they able to control the trademark? Were they the ones, being able to give instructions to Tom's company on what to do with the trademark, how it should look, how the quality of goods should be? It seems unlikely, right? And so, matter of fact, and we pulled all these documents from the USPTO database. This is a copy of a portion of the assignment that was filed. You could see here that Yi and Dubin Sports assigned the trademark into TEB, which is Tom's initials, Capital Management, and the assignment document filed. So again, this was filed in 2017, the assignment into Tom's company, the original filings made, you can see here at the top of this, November 2016. Just a head scratcher. And honestly, if Tom ever sues one of our clients, the very first thing we're going to do is say, hey, wait a second, we don't think some of these registrations here are valid because they were filed in an incorrect entity off the start. So this would be a case, if for some reason, they got some legal advice and they said, wait a second, why are these trademarks in Yi and Dubin Sports? Let's move them to TEB Capital Management. And again, we don't know anything about this case, and it could be mitigating circumstances. So I got to be careful about throwing Tom Brady under the bus too much here. But if it is what it seems like, the right answer would have been, no, we're not going to assign these. We're going to refile them. We're going to file brand new applications in the correct entity name, and we're going to get rid of these old applications. We're going to surrender them, or we're going to let them expire, whatever we're going to do, because they're just not enforceable. And so, you can see this at the highest levels, where people make these mistakes, and it's always surprising to us to find this, but nevertheless, you can see it here in black and white. Couple of common, we've talked about a number of mistakes, but here's just a final kind of slide on it, if you will. Another mistake that we haven't mentioned is that folks just put the wrong name of the company. Again, this could be a correctable error, but so many people will shorten their company name. So they might say to you, yeah, my company name is, I don't know, XY Inc. And it's really like XY and Sons Inc. But they've, in their mind, shortened it because they always just call it this, and they've taken off the last word for some reason. And they will tell you that this is the name of the company. So again, we always verify this. You have to go to the Secretary of State website. You need to make sure you've got the correct name, the full name of the entity in there. You don't want to just take your client's word for what the name of their company is. You would be surprised how many people don't know the answer or think they know the answer and don't. And then this is just a repeat of a point I was making earlier, which is like, you got to make sure your corporate fees are paid up and all the filings are made and the company's in good shape. You don't want to have a company dissolved and go in and file a trademark application in there. Just not a good idea.
And I think that number one is in particular important because, like Josh said, the USPTO is not going to check this. They're not going to kind of ask you for corporate documents. They're not going to do anything like that. And it can become particularly painful in an acquisition process or in due diligence, where they ask for everything and then they suddenly find out, well, these are in a different entity name than what everything else is. And then there's a process you have to do to correct it. Right now, it takes about 6 to 7 months for the Patent and Trademark Office to actually correct their records. And so it could be a significant time and expense and confusion if the name doesn't match the actual corporate name in the U.S. Patent and Trademark Office.
Great point there, especially on due diligence. These kind of things certainly rear their head at that point, no question about it. All right, so that, if there are any other questions here about who should own a trademark, we've kind of beaten a dead horse at this point, I think. But if there's any other questions, and if we haven't made it as clear as day that this is such an important issue to get correct, but if any other questions come in, we can always jump back to it as well.
Yeah, I'll do a final kind of mention that if you are trying to determine whether or not one of your clients or you are infringing on a trademark, then this is not kind of a silver bullet that's going to win the case for you. Ownership mistakes can really make it hard for someone to show and prove they have trademark rights, but there still could be underlying common law rights. And so just be aware that this is about maintaining and utilizing a trademark registration more so than something that would kind of instantly give you the get out of jail free card. It has happened to us where that did hinge on the fact that they didn't own a valid registration, but that is somewhat rare. So just kind of keep in mind that this is a part of a bigger thing that you should be doing when reviewing trademark claims, is looking at opposing parties' trademarks, and then also when you're about to enforce your own, making sure all your things are in order.
Yep. Great point.
We got a question that I think is the perfect transition as far as if they file, and if an individual files in their name but later transfers it to an LLC or a corporation, can an assignment be filed? And that is exactly when an assignment is perfect. That is, so that trademarks can be sold, they can be transferred, they can be bought, they can be used as collateral in a loan. Trademarks can be licensed. And so there's all these different ways you can utilize a trademark. And one of the most common ones is transferring a trademark from one entity to another. And I think that that is, it's very common, and you see this in a variety of different types of asset transfers, but I think that trademarks are actually unique from any other type of property transfer. And that even includes copyrights and patents, because trademarks only exist because of their, and this is going to get a little philosophical, but they only exist because of their meaning to consumers. If a trademark does not have underlying goodwill, this idea that it has some meaning to consumers, that they tie it to a specific product or service, then it has no real value. The right to use a name is not the same thing as obtaining that underlying goodwill and meaning in a name. And so that's where trademark assignments become extremely important, to have what I kind of jokingly refer to as the magic words, but they are, it's important that everyone who is contemplating either signing an assignment or creating an assignment understands exactly what's being transferred, because a lot of the asset transfer purchases we look at, a lot of the things that we see that we get handed and say, look, I transferred all of the stuff I own, doesn't specifically include that goodwill. And in certain cases, that can be absolutely fatal to what both parties are trying to do. And it can take some backtracking. It can take some what we call nunc pro tunc assignments, where you're memorializing what actually happened, even if it wasn't written. And that's what our next section is going to talk about. What exactly goes into a trademark assignment? When can you utilize it? And what are some best practices? So a trademark assignment, it does not, and this is, I'm going to say this with a caveat, does not need to be written. You can transfer underlying trademark rights through an oral agreement, through an implied agreement. However, in order to record that with the US Patent and Trademark Office, it must be written down. You can't just say, yeah, we shook hands on this and transferred it. So knowing what goes into that written document is extremely important. And it's not your normal things that you would see in a typical property transfer, or something like that that says, on this date, I transferred this asset to so-and-so. That does not address this idea that there's something else being transferred here, that what you're actually getting is all the work I put into this trademark. And so once that occurs, then the next person owns it. And what they actually get is all of the prior use of that trademark, including the trademark application, all the things that were transferred, all then transfers to the new user. Otherwise, if there's a break, and that's called chain of title, if there's ever a break in the chain of title, it's almost as if that trademark hit the reset button. And that can be, for many reasons, not what ideal for anyone involved in that transfer, because you want that early first use date. If a trademark's been used since the 70s and you acquired it from that company as a part of a deal, and you want to be able to say, yeah, I own those rights through the predecessors straight back to the 70s. And if you can't, then someone along the way could actually say, well, you stopped using it, or you don't have a valid chain of title, so I actually do, and here's when I started using it. And then you get into a really big issue where two people are kind of now arguing in an infringement situation. And so it is important to make sure that the assignment clearly spells out its three main things that you need to make sure it shows. And I think that is on the next slide. And that is the transfer of goodwill. And that you're saying that all underlying goodwill is being transferred from one entity to the other. The other part is any past royalties do not automatically transfer to the next person. So if there were any kind of royalties owed by a past licensee, if you want to collect those as the new purchaser of this trademark, or if the next person's expecting to get that, you have to put that in writing to make that very clear. And then the third part is any past infringement. That ability to sue past infringers does not automatically transfer over in most cases either. So those are the three things that we call kind of the magic words that I look for in every trademark assignment. And there's some exceptions to that when it comes to certain things, but it's not something that is a one size fits all, but the underlying goodwill is the one thing you absolutely must include, because if without that, there is no trademark being transferred. And at that point, you're basically just transferring this general right to use this, or even an agreement that the old person's not going to do that anymore. And so actually I just got a question in that says, what happens when that break in title happens? And that is actually, most of the time, the agreement is one party is going to stop using it, the next party is going to start using it. So the first party abandons it and the next one starts. And you can see how that break is not ideal, because you don't get any of the rights of that first owner. And I actually had a situation that happened maybe about 6 months ago, where a client came to us and said, well, I bought this business and I want to franchise it. And so we bought, and he sent me, and it clearly states you're buying the equipment, you're buying the sign, and you're buying the right to call yourself this name. But there's someone else that also is going to have this right. And they're going to, so what they actually bought was a license to the trademark. They didn't buy the actual underlying rights. And they spent close to $1 million to acquire this right to call their restaurant something that they did not have exclusive rights to. And I think that is, it has been the last 6 months of trying to dig out of that and trying to clarify that. How could that possibly be the case? And it appears there's some significant issues to dig through there. And I think that's where, if you just are very clear in your transfers of things, of what's being transferred, you can avoid a lot of that. I think then the other thing is this idea that you are transferring it in a clear path. Sometimes what happens is, and we have an example of this, where there might be a name change somewhere along the way, and then the rights transferred to a holding company, and then it transferred to a second company, and you need to be able to kind of connect the dots throughout the entire history of that trademark to have a single chain of title, so that you are not in a situation where your trademark's either being valuated for an acquisition or something like that, or you're trying to enforce the trademark rights, and suddenly you're in a situation where you're defending whether you even own the trademark in the way that you believe you do. And so I think that's where it just needs to be very careful to include those things. And I think we have a few examples that should help illustrate this, but I think that's just, if you've ever done an asset transfer, just know that there's always an assignment clause in most of them that says, I assign this, but unless it has that special wording, then it may not be as effective as both parties intended it to be. And I think the one thing I'll add before we kind of go into the examples is, even sometimes it might be beneficial to have a separate assignment document that reflects what's in the asset transfer, because you have to record it with the Patent and Trademark Office, and that is a public document. And we've had situations where we've had to heavily redact this purchase agreement in order to put it on the public record, when we could have just done a short form assignment or something like that clearly just was pulled out. It's its own thing, and that is what we then file with the Patent and Trademark Office. And it's much cleaner and avoids any kind of disclosure of any kind of deals or things like that might have occurred. So I think that would be a recommendation, even if you do have it in an asset purchase agreement, to consider having a separate assignment that reflects that as well, that can be submitted to the Patent and Trademark Office.
Yeah, I almost require that, because there's so many times where, corporate counsel bring us in and say, hey, we need to get this trademark assignment done. And, we got this deal closed. They have all the documents signed, and then we need to get this filed with the trademark office, and there's no separate trademark assignment. And 9 times out of 10, the language in the asset purchase agreement is insufficient to transfer the trademark rights. And so you're actually going back and creating a new document, having to basically kind of plead with the parties to go sign a document again related to the transaction. So really important, I think, to, if you're working on a transaction where there's going to be a transfer of trademark rights, and I don't say this to, it obviously sounds like a biased statement, but if you are not versed, or you don't feel comfortable understanding how to transfer those trademark rights, getting somebody to, a trademark counsel to look over the agreement and help you out a little bit. And hopefully don't do it the day before it's supposed to close, because I can't tell you how many panicked phone calls I get about that, and very hard to adjust and get it done in that kind of short time frame. So let me go over just a quick example of what we've been talking about here, because this is a kind of a common scenario that we'll see. And I've had this slide up for a little bit. So let me show you the visual of it here. The first step is that, let's say you have a company, we'll call it ABC Inc., and they register the trademark, right? And the trademark here, if you can see my example here, it's the trademark is Eagles. It's a brand of gloves, not related to the Philadelphia Eagles, but inspired by the Philadelphia Eagles. So ABC Inc. owns this trademark for Eagles. They register it. XYZ LLC comes along and buys ABC Inc.'s assets, including the trademark, right? Then at some point, XYZ is going through a corporate restructuring, and they convert. There's a corporate conversion from the LLC to XYZ Inc. So now they're a corporation. And this is where your client gets involved, and your client comes in to buy XYZ, now XYZ Inc. and its assets and this trademark. Well, if the trademark registration is still owned by ABC Inc. as far as the USPTO is concerned, or XYZ LLC, and nobody has kept the registration record updated, your client's going to need to make sure that one by one, these different transactions are recorded with the USPTO's assignment division in order to properly bring the chain of title to your client. And if you can't go from ABC Inc. to XYZ Inc., or you can't go from ABC Inc. to your client Inc. because you have all those intermediary transitions. So we actually, believe it or not, get involved in transactions where nobody's paid attention to the PTO for like 6 or 7 years, and we've got to kind of go back in time and try to recreate these documents necessary to get the trademark transferred along the line at the USPTO in the way it should be. So again, if your client is purchasing a trademark, you need to make sure that you're able to track the ownership through the previous owner or owners, and make sure that ownership has been properly documented to make sure the chain of title is good. A question in the chat here about assignment fees. What are the costs? Yes, actually, USPTO fees aren't bad on this. They charge you $40 to transfer a single trademark, and I think it's $25 now for any additional trademark on that assignment. So really, it's not a government fee issue typically. I mean, those are pretty nominal. The challenge is that, everybody, of course, everybody thinks everything is easy and can be done very quickly, but you can see how much thought might have to go into this. So the question is, and not even necessarily a thought, but just like the checking and making sure that you understand, that the lawyer understands what has happened. So it's really more or less the time that goes into all the checking and checking the boxes and making sure you got everything right for the client. And that's where the major cost comes in on trademark assignments.
Yeah, and I'm confident that everyone on this call, if I sent them a template trademark assignment, could fill it out. I without a doubt believe that. It is a one-page document most of the time, and it really comes down to the legal considerations of, when are you filing this? Does it reflect the actual realities of what happened? Because if it doesn't, that could be a break in the chain of title. And so I think that the actual preparation of the assignment and the filing of it is relatively inexpensive and not very time consuming, but the stakes are high, and it is very difficult to unwind a trademark assignment, and can lead to a situation where if two people are both claiming rights to a trademark, then at that point, who has the valid assignment and how did that kind of work out? So I think that's where the challenge is with trademark assignments.
And the last thing we want to mention here is a potential landmine that you can step on. And that is that if you've been one of our prior CLEs, you know that there's different, what we call filing bases for a trademark application. In other words, you can file a trademark application once your client has already begun selling products or services. You can also file a trademark application before any products or services are ever sold. If you file the application before a product or service is offered and sold, it's called an intent to use application. There's a very specific rule against assigning intent to use applications unless the underlying business is being transferred along with it. In other words, they don't, what the USPTO wants to prevent is what they call the trafficking of trademarks. So you could imagine where some entity files 2,000, 5,000 trademark applications and seeks to sell those applications off to somebody that might want them. And the idea is you can't do that. And so if you're going to transfer a trademark application before you have actual sales of goods and services, the entire underlying business has to be transferred as well with it. And that's slightly complicated as far as the thought process there and what might constitute the underlying business or not. But again, a trademark registration could be invalidated if it was if during the application process it was assigned during this intent to use phase and it was not done properly, using the one exception to this basically rule that you can't transfer an intent to use trademark, that all the underlying business went with it. So just a landmine, if you see something out there like this, you want to be extra careful with it.
And then where we see this most frequently is clients that say, I've got this great idea. And I've got like 20 great ideas for brands that what I'll do is I will get them approved by the Patent and Trademark Office, and then I'll see if someone wants to use them. And that's something that I think is this, like, there's a lot of people with great ideas out there. That is where we most typically see this issue, is that if you file a bunch of intent to use applications and then you're looking for people, that is literally the trafficking of trademarks that they're referring to. I've also heard it called warehousing. They don't want a situation in which someone's like, I've got this list of trademark, which one you want? Because that is not the purpose of the US Trademark Office. The other place we typically see this come up is when a company is switching from, and I'm actually doing this right now, so this is not a hypothetical, that they own a business, they are now creating a holding company. You cannot transfer the things filed under an intent to use from an operating entity to a holding company until that trademark is in use and that you filed what's called a statement of use with the US Patent and Trademark Office. Otherwise, it would be an invalid assignment. And that's just because of these rules that I think in that situation doesn't make a ton of sense, but it is something that they're just the purpose of it is to keep people from just filing things and then trying to pawn them off to other people in a scheme of some kind. So it's just the rules to be aware of, but not something that comes up a lot.
Yeah, but it's these nuances that makes it difficult sometimes, and again, they're very not obvious and sort of these corners of trademark law that if you're not aware of can easily trip up even an experienced practitioner. So a couple questions in the chat before I move on. One about a standalone document for the purchase of trademark rights when there's a sale of an entity. Yeah, so I might have mentioned this a little earlier, but if you're doing an asset purchase agreement, my strong suggestion is that the asset purchase agreement should reference an exhibit, which is a trademark assignment, and incorporate it by reference. And then that a separate assignment, which is, as Eric mentioned, typically just a one-page document, gets filed with the trademark office. So you're not filing the asset purchase agreement with the trademark office, making it a public record. And it's a lot cleaner to structure the agreement that way, to have to say that the asset purchase, yeah, you're buying the trademark and the rights per exhibit, C or whatever, and that exhibit C is the actual trademark assignment. That's really the best practice and way to do it. Couple other questions. Sorry, just kind of reading in here.
And that can a URL be a trademark? Mm-hmm. And there's another one that I just answered this question today with a client, that the ownership of a trademark of a domain name does not alone give the owner of that any kind of trademark rights. A domain name only begins to act as a trademark when it's used as a brand. And so you'll see that someone calls themselves when the Supreme Court recently, there was booking.com, this idea that they're using that as their trademark. And that is when it begins to get trademark rights. And so purchasing a trademark, a URL would not reserve any kind of rights. And they can be sold later as long as it's not something that is registered or used in bad faith. And that's kind of, I think, maybe that'll be our next CLE, Josh, is about domain name disputes. But there's a lot of nuance there because domains are treated unlike any form of intellectual property. And so it's a completely different thing. But that would just be something to be aware of, is that, when you're trying to kind of navigate that, just to know that there is instances in which URL can be a trademark, but it is not in and of itself a trademark. It's more of an address.
Yeah, for sure. The next question has to do with if does a trademark attorney do an assignment for someone in a state they're not licensed to? Is there any kind of ethics requirements there about being licensed in a particular state? Well, yeah, it's a great question. I mean, I think there's the open question in law practice these days as to what constitutes unauthorized practice of law, given that just about everybody exists everywhere, and there's not a lot of. It's not like the law is stops at the state borders much anymore. Trademark law is a federal practice, so while certainly an assignment could be governed under state law, it's really dealing with the federal registration. So, the vast majority of assignments that we handle tend to be from individuals that are reorganizing their companies or their corporate structure, and they want to get a trademark from one entity to another. In that case, I think there's probably very little risk that you're not really just dealing with the federal registration under federal law at that point. It doesn't seem to make a lot of sense to have to get a state, an attorney in Delaware involved when two Delaware entities are just transferring the trademark between. That said, when there's more of a asset purchase agreement involved or something, typically we're not involved in that process, given that our practice is very much limited to federal law. So at that point, you do have the local counsel typically handling the purchase agreement. And, as trademark counsel, then we can kind of come in and say, this is what's needed for the federal trademark registration to transfer it. And if the local counsel would have any comments about the assignment under local state law, they would make them. I can tell you that I've never had a local counsel make any comment about an assignment on a federal trademark registration that there's an issue with the way it's written under his or her particular state law. So it's normally not, I wouldn't be too concerned about it, but I think it's the right way to think about things, and always make sure that you feel comfortable that if you're not licensed in a particular state, you're not practicing law there. But yeah, those are very hard questions, the way that the world works today. And arguably the bar is a little bit behind in addressing them.
Yeah, and then kind of to jump back to intent to use trademark assignments, that a question was asked about whether you have to wait until the statement of use is filed or the statement of use is accepted. And if I could cold call on one of our associates who's on the call, who just answered this question from the Trademark Manual of Examination in procedure, it is when it's filed. So once a statement of use is filed, that does allow you to then file an assignment of an intent to use application.
And the last question at the moment is for breaking the assignment out from the asset purchase agreement. What about the consideration? Well, the consideration is in the transaction, right? So the consideration is, you're buying the company for $1 million, you're getting all the assets, including the trademark. In the assignment document, the language might be that for the valuable consideration mentioned in the asset purchase agreement, you're referring back to that agreement, trademarks transferred. That's all you really do. So it's just a reference back to the APA at that point. Great questions, and thank you everybody for the participation. It makes our lives and jobs a lot easier here. So thank you for that. We've got about 10 minutes left. So if any other questions come in during this time, we'll be more than happy to answer them. I'm going to start by I'm going to do a little story time first. As you can tell, I kind of get all my examples from sports. Just makes it fun, at least. Luka Doncic, I don't know how many of you are familiar with him. Very, very good basketball player for the Dallas Mavericks. Recently got into a trademark dispute with his mom. Yes, not even a joke, really his mom. So The situation here is kind of unique. Luka started playing basketball professionally when he was just 16 years old. His mom, whose name I'm not going to try to pronounce here for fear I'm going to get it completely wrong, helped him with his business interests, because can you imagine a 16-year-old kid trying to handle fame and fortune, right? Even 18 years old, 19 years old. So anyhow, long story short, they started filing trademark applications, and his mom listed herself as the owner. So when you file a trademark application for a living individual's name, if it's not being owned, or if it's not being owned by that actual individual, even if it's just being owned by a company where that individual might be 100% shareholder, you have to submit a document with the USPTO saying that the individual, in this case, I, Luka Doncic, I consent to my mom owning my trademark registrations. So he signed that document, and it was filed with this trademark, this logo, this Luka Doncic logo. So his mom's listed as the owner. Matter of fact, I don't have the tweet here, but we were doing research one day and I saw this, and I just tweeted out, fun fact, all of Luka Doncic's trademarks are owned by his mom. Don't understand why, but that's who owns his trademarks. So as our story goes, Luka's gotten older now. He started his own company, Luka 99 Inc. And Luka 99 Inc. filed a trademark application for what else but Luka Doncic with the USPTO. Well, he filed a trademark, and the owner is listed as Luka 99 Inc. for Luka Doncic. And when the examiner got his application, the examiner refused this new application because this logo that you see on your screen still was registered by his mom. And they say the owners don't match. The mom has priority over Luka 99 Inc. because that was registered first, so you're denied. Well, this is normally when you might say, hey, Ma, remember, I let you own the trademarks. I'm 16 or whatever. I need to get them in my company now. And that ownership might have been okay. Like, it's not ideal that his mom was listed as the owner. Ideally, they would have set up a corporation or an LLC to own the trademarks even at that time. But at that point, the mom would have just had to sign over the trademark to Luka's company. She does not. So it appeared that she refused to do this. Because what ended up happening then is Luka filed, and the reason we know this is because Luka filed something called a petition for cancellation. Petition for cancellation is something you could file with the trademark office to cancel a registration on some grounds. And we'll make these slides available if you want to read through. This is from the pleadings itself. This is paragraph 4 of the pleadings, where it talks about how Luka had success on the basketball court at an early age. And not surprisingly, he relied on his mom to provide assistance and guidance for off-the-court business opportunities. And that led to a registration to be owned by his mom with his consent. You can see it's spelled out even right here in the pleadings. And as the pleadings went on, it talks about how Luka set up this company, and he revoked that consent because he's trying to get the trademark owned by his own entity, clearly indicating his mom is not playing along with this game, basically, right? I mean, this would never have gotten filed if his mom was just giving him the assignment that he was asking for. And therefore, he was seeking to cancel the Luka Doncic trademark she had filed so that his new one could be approved. This is how the pleading ends. So this goes big in the news, right? Because the minute we see this, we put it out and other reporters pick up on it. It went even further, where Luka's mom filed a motion to dismiss, like a 12B6 motion here, essentially, claiming that his filings lacked a valid ground for contesting it, that her ownership was proper, she was granted. So it's like, wow, here you have a son and a mom, and you have no idea in public that there's this issue going on, but behind the scenes, she's trying to hold on to these trademarks, right? And it's going, again, as far as filing a motion to dismiss, which is kind of unbelievable. Fast forward to today, all of a sudden, a couple months go by and the opposition gets dismissed. Or I'm sorry, the cancellation action that Luka filed got dismissed. And it looks like they resolved it. And sure enough, if you pull up, this is the USPTO assignment division here, you can see that here's the abstract that his mom, who's listed as the assignor, assigned it to his company, Luka 99 Inc. So, they finally got her to sign it over, but you don't know what again, when you look at the actual document that was filed, doesn't mention why, it doesn't mention if there was, how much money was paid, if there was money paid. We'll never know that, because when you draft the assignments, again, as part of like a settlement agreement, even, the assignment is done as an exhibit. It's not done as part of not in the actual settlement agreement, presuming there was one here. But I don't know if it's a happy ending to our story. I mean, Luka owns his trademarks now, not his mom. But obviously, you hate to see a mother-son relationship deteriorate to the point that you're actually involved in a trademark dispute. Also, one of the first trademark disputes I can remember from a mother and a son. So go figure.
They didn't cite your tweet, Josh, in the exhibits.
I don't think they did. I don't think they did. They probably weren't terribly thrilled with with us putting it out there. But nevertheless, thought it was an interesting trademark story and one interest around trademark ownership.